See, that's what I have on the course list.
Yes, PLC, my lord. I'm
All
sorry,
right,
my
thank
lord.
you. Yes.
Mm.
Do
What
you have
is
any,
proposal?
do you have any parties in courts?
No, my lord.
Any counsel in courts in
No,
Sokoto?
my lord.
All
No,
right.
my lord.
Then online, do we have any? Yes, you are for defendants. Claimant counsel, I don't think I have anyone online. Yes, maybe it's trying to connect. Let's take appearance of defendant who is physically present first. Yes. Yes.
Jennifer. Okay, sir.
Jennifer.
Yes, my lord. N-I-F.
Yes, spell the last name.
G-W-O-K-E, my lord.
Yes.
Defendant.
For defendant.
I'm holding the brief, sir.
Yes.
Of Valentine.
With brief of
Valentine.
yes.
Ajibo, my lord.
Valentine.
Ajibo.
A-J-I-B-O,
my lord. Yes, sir. For the defendant, sir.
Do I have any counsel for the claimant online? Was it Munirat? Okay, he told you. Because we had Umar Ali.
Cargo.
Yes.
Cargo.
Yes, cargo.
He's trying to come.
Yes, I think they had this, but then there I did, we had, how about the other defendant? Defendant, how many of the defendants? Okay, just one. Okay, just one. So it's okay, it's just the claimants we need to. So if they are not ready, then since my ruling is ready, I may have to proceed and stand this one down again because it's trying to get connected. Yes. Sokoto.
Yes, my lord.
Would allow a few minutes for claimant counsel to get connected. Here in Abuja, we have the defendant counsel before me.
Okay, my
While
okay, my lord.
we'll take SK04. So we'll stand this
Okay.
matter down for 15 minutes.
Okay, my lord. As court please.
Case is stood down to allow claimant counsel to get connected. So call the next one.
Okay, my lord. NICN/SK/04/2023 between Abdul Wahab Dauda Abdullahi versus Salim Bank PLC. The matter is for ruling, my lord.
Yes. Parties?
Yes, my lord. The claimant is in court, my lord.
That's Munirat. Is it Munirat?
Yes, my lord. My lord, the claimant is in court.
Where is he?
Abdul Wahab Dauda Abdullahi.
Yes,
he's logged in as Abdul Wahab Dauda Abdullahi.
Yes, Abdul Wahab, that's the claimant, yes. Claimant.
Yes, my lord.
Defendants. Yes, announce your appearance, please.
Thank you, my lord. May it please the court. I'm Munirat. Oh, yeah, yeah. My appearance is for the claimant, my lord.
Yes, defendant counsel. Yes. Bimbo Atilola for defendant, yes. Yes, counsel. Yes, Munirat.
Yes, my lord. The case was adjourned today for ruling. Subject to the convenience of my lord. We are ready.
Yes, the court will deliver the ruling since same is ready.
Yes, my lord, the case was adjourned to today for ruling, subject to the convenience of my
Yes, the
lord.
court
We
will
are ready. I'm sorry, my audio split.
give me your red pen, please. So I shall proceed to deliver the ruling.
As the court pleases.
All right, okay. The defendant on 20th August 2024 filed a notice of preliminary objection dated 16th August 2024 and brought pursuant to Order 17 of the rules of this court. Paragraph 3, sub 2, 3 and 4 of the National Industrial Court of Nigeria, filing of application motions in trade union matters and marking of exhibits practice directions, number 1, 2022, and under the inherent jurisdiction of court, praying as follows. A, order of court striking out the suit for non-compliance with the mandatory requirements prescribed by NICM practice direction on marking of documents and exhibits. B, and for such further orders as court may deem fit to make in circumstances of case. The objection is hinged on 4 grounds: claimant statements of facts, witness statements on oath, with accompanying processes did not comply with the mandatory provisions of the practice direction on marking of exhibits and documents. B, non-compliance of the statement of facts, witness statement on oath, etc., is fatal and the suit is liable to be struck out. C, said NICM practice direction came into force since 13th of June 2022. And D, court has consistently held that non-compliance with the practice direction is fatal and as such suit is liable to be struck out. In support of the objection is written address, wherein defendant applicant submitted a loan issue for determination of court, thus whether the suit ought to be struck out by this court for non-compliance with the mandatory NICM practice direction. Counsel in his submissions on the issue argued that the suit ought to be struck out in line with the provisions of paragraph 3 sub 2 and 3 sub B of the NICM practice direction 2022, which he reproduced for ease of reference, and to the effect that all documents attached to any statement of facts or defense or reply to statements of defense and their respective witness statements or note must be marked serially in the manner done for originating summons. Also, that the effect of non-compliance, with such mandatory provision is striking out of the entire suit in the case of the claimant's statement of fact or reply to statement of defense. Counsel further argued that the said practice direction came into effect on the 10th day of June 2022, while the present suit was filed 31st day of May 2024, without adhering to the provisions under reference, thus that they are incompetent and not to be struck out as the words used therein is shall, which implies it is compulsory requirement. Additionally, he referred the court to a number of decisions held by various divisions of this court on the matter, which has been consistent with the position of the practice direction by striking out such suits where it was the claimant's process that was found to be non-compliant. This one of the cases amongst others is Email Cone versus Keystone Bank Limited, suit number NICN/LA/321/2020 by Honorable Justice Nweneka, amongst other cases cited. In conclusion, applicant counsel urged the court to grant this application and strike out the suit for want of compliance with the mandatory provisions of the practice direction. Claimant respondent did not file any process in reaction to this notice of preliminary objection, but stated that they have an objection on point of law. They did not see the need to react to defendant's objection for the reason that defendant had no appearance before the court. Responding to this, defendant applicant counsel posted that failure to file any response to their MPO shows that they have consented to the merits of the MPO and have taken away the rights of audience from the claimant respondents. Also, an MPO can be filed at any time, and that assuming they are out of time, as contended by respondent counsel, they argue that because the issue of the objection is on jurisdiction of the court can still look at it and at best direct applicant to make the proper application to regularize and pay penalty before ruling. He maintained his stance by praying the court to strike out the entire suit. Now the decision of the court. This case was filed at the instance of the claimant challenging his dismissal from the employment of the defendant on the grounds of financial fraud, amongst others, stating that dismissal was unjust and without basis. It is imperative to set the record straight that the instance suit, which is dated 25th September 2023, was filed 29th September 2023, contrary to date of 31st May 2024, as the applicant's counsel, and as such is the date that shall be considered in deciding this application, and I so hold. That being said, I shall resolve the point of contention of respondent counsel. The applicant has no appearance before the court, and thus they did not deem it fit to react to the MPU. It should be noted that respondent counsel did not file any process to challenge the appearance of counsel for the applicant in that regard, and as submitted by applicant counsel, respondent's failure to file any process in response amounts to an admission on the subject of contention, and I so hold. See Ogwejefo and Ogwejefo, 2006 LPLR 2308, Supreme Court, amongst other cases cited. Moving on to the substance of the notice of plenary objection, it challenges the jurisdiction of this court to hear and determine this suit on the basis that claimant's statement of facts, witness statement on oath, and documents annexed thereto were not marked as mandatorily required by the provision of paragraph 3, sub 2, and 3, sub B of the NICM Practice Direction 2022. The Practice Direction came into effect on June 2022. Paragraph 3, sub 2A of the said Practice Direction, which I find not particularly applicable here, provides thus, and I quote, in the case of a claimant, the statement of facts and witness, statements or notes must clearly indicate all the documents to be relied upon at trial of the case and attached same. The attached documents must be marked serially in the manner done for originating summons. A perusal of the statements, claimant statement of facts, witness statement of note, and the documents attached, which consist of his employment letter with Oceanic Bank, offer letter with Access Bank, claimant's letter of resignation, amongst others, were not marked as required in the provision above. Also, paragraph 3, sub 3B1 provides thus, where a process that does not comply with the provisions of this practice direction is accepted for filing by the registry of the court, the judge to whom such process is assigned for hearing shall treat such process as incompetent and shall, 1, if the process is a claimant statement of fact, reply to statement of defense, and or witness statement or note, strike out the entire suit. I have also taken note of the various decisions of my learned brothers in various divisions of this court, and I'm very much persuaded by the said authorities which have given interpretation to the above provisions as being mandatory. Hence, having found the claimant's process to be in defiance of the provisions of paragraph 3, sub 2, and 3, sub B, I consequently hold that claimant's originating process is incompetent and accordingly struck out. I so hold. Ruling is hereby entered.
As the court pleases, thank you, my lord. We are grateful for the ruling. We'll do the needful.
Yes, thank you, counsel.
Yes, thank you, my lord.
Yes, registrar, so we have to wait to see if SK06, if the claimant counsel is now connected. Yes, you can have this slide. Registrar, call that case again that was stood down, please. Sokoto.
Yes, my lord, I'm hearing you now.
Call the case again that was stood down.
Okay, my lord. NICM/SK/06/2024 between Sani Suleiman and 29 others versus Kaduna Electricity Distribution Company Limited, KEDCO in bracket, for the case proposal mentioned.
Do we have the claimant's counsel now connected, please?
May it please my lord.
All right, thank
My
you.
Lord, I
Yes,
sincerely apologize
no,
for
it's
my.
okay.
Thank you, my Lord.
Yes, please announce your appearance.
May it please this honorable court, Umar Aminu Kalago.
Yes,
My Lord, I humbly appear for the claimants. Thank you, my Lord.
welcome. Yes, Cargo, I have the defendant's counsel here, Ugoke. And yes, you said you have filed, yes, to file your processes in defense. Have you been served with any of the, I have the application here. Have you been served, counsel?
My Lord, we have not been served.
You can hear that.
However,
Yes.
the council have sent a soft copy of the processes to me.
Yes.
And my Lord, if I may be guided, my Lord, the clarity of the motion is not very clear. If I could hear the orders, if it is not harmful, my Lord, we will not be opposing it.
Yes, counsel, are you connected?
I am, my Lord.
No, not you, Clement counsel. Next time you ought to be, yes, so that he can see you and hear you as well. But you can hear, so you have to, I don't know how, if he will be able to hear you. Maybe you come forward here, yes. So, but he said he's been sent forward with the soft copy, but all the same, I don't think, I think, counsel, I have it before me, it's a harmless one, but all the same, I will allow counsel the leave to proceed and move that application. Yes, so you have been served. Claimant counsel, I'll take it that you are aware of you have said that you were sent the soft copy.
My Lord, he sent a soft copy to me.
Fair. Yes, she will read out. Can you read out the prayer so that, yes, just in the interest of justice, let's have it.
As the court pleases.
Honorable Court, extending time within which the applicant can file its conditional memorandum of appearance.
Can you hold on? Can you hear her?
Yes, my Lord, I had that one.
Okay, go ahead so that.
Yes, sir. And before you have a motion for
Yes, yes.
pray this honorable court, extending the time within which the applicant can file its conditional memorandum of appearance and statement of defense. And order during the applicant's conditional appearance and statement of defense filed out of time as properly filed and all necessary defaults having been paid, my lord. Attached to this application is a 6-paragraph affidavit deposed to by one Messi Suetan. And you're having paid default fee before the court.
Yes, I have it here. The assessment itself, you have paid the default fees, yes.
We urge your lordship to grant the application as free, sir.
Yes, Cargo, that's all the application, that's what the application is all about, is to regularize the processes of the defendant. The conditional memo of appearance has been filed and statement of defense.
Rightly guided, my Lord. My Lord, the claimants are not opposing this application.
All right, I'll have you on record. Thank you. So in absence of any objection to the said application or opposition to same, the orders are all granted as prayed in the application of the defendant applicant dated and filed 6th day of December 2024. Yes, Counsel.
My Lord, in the circumstances, my Lord,
Yes.
my Lord, we would be asking for another date
Yes.
to enable us peruse the defense of the defendant. And if need be, my Lord, we file
your reply.
Yes,
all right.
But my Lord, I urge this honorable court to adjourn this matter.
Yes.
Or PTC, probably if we file, we can proceed to PTC, my Lord, if that is possible.
I didn't get to. I didn't
my Lord,
get to.
I said I'm suggesting, my Lord, if we could take a date for the commencement of PTC, my Lord, pre-trial, because we'll have enough time to read and file, and if need be, file our pre-trial questions and answers.
Well, I will give you a date for definite hearing and sufficient time for you to meet with defendant counsel and sort out all documents and anything you need to make use of at the trial, prepare your witnesses. I think that's how we are going to go about it. Yes.
My Lord, sorry, my Lord, I am, won't we have a pre-trial, my Lord, in this?
No, there's not going to be a pre-trial conference, please.
Okay, my Lord.
Yes. So, you can meet with the defendant counsel and sort out all your documents and witnesses, prepare your witnesses. Yes, there won't be any pre-trial conference with the courts. Yes.
Okay. So, my Lord, in the circumstance, my Lord.
You're asking for a definite date. And within that time, definite date for trial, within before that trial date, if you need to reply to the defendant's processes, you do that.
The court pleases.
Yes, and serve on the defendant, file and serve accordingly. And on that date, you prepare, your witnesses will have been prepared before the date.
As the court pleases.
Sort out all the documents so that we will not have any hitch during the trial. So sort out the documents, agree. You have a position to agree on the documents which you want to make use of on trial, and the event that you may want to, if there's any reason why you may want to object to any of the documents, then that, so we'll have those ones sorted out. So that it's not when you get to court that you start trying to do that sorting, which is usually a hitch for speedy trial.
The court pleases.
Yes. So you are well guided. You are well guided by the rules of courts.
As the court pleases.
Yes, all right.
We will be asking for.
Let me have the diary, please.
Yes.
When do we have the Sokoto matters? Okay, counsel, I think for Sokoto now, we have a date for 11th of February. So you may check your diaries, please, both counsel.
Okay, 11th of February. My Lord, for the claimant, 11th of February is convenient, my Lord.
Yes, defendant counsel, it's convenient, okay. The defendant counsel equally says it's convenient.
God pleases.
So the matter is further adjourned to 11th February 2025 for definite hearing.
As the court pleases.
All pleadings shall be filed and exchanged before the next hearing date. Equally, counsel on behalf of parties to settle all documents for use at the trial and equally prepare witnesses.
As the court
So that should be all regarding Sokoto.
Yes, my lord. That's all for Sokoto.
All right. Thank you, Counsel Cargo.
Thank you, my lord. We are most grateful.
To exit the site now.